also sell it as a 20-story hotel site.
Was that developed separately, or was that?
At the same, simultaneously.
So
the rights were sold separately, yeah.
Right, but
Yeah.
they built the whole project all
They
together.
built it all. Yeah, they didn't come and stack on a hotel on top of the shopping center.
Could you potentially do that?
I think you could if you could physically make it work. You know, I think not, probably not in this case where you'd be on top of a 3-story shopping center, but clearly on top of a road, of course it's done. The road's been there, you know, that interstate's been going through Atlanta for 40 years, and all of a sudden it has buildings on top of it. Clearly they're built later, means the right of way is big enough that they can allow the foundation of the buildings to go down. But I mean, it's interestingly, it's where you looked up at the sky before, you're now looking at a building and making, hugely increasing the value of properties if you think about selling them again and again for the airspace that people previously thought was worthless. It's sophisticated, it requires lots of documentation to establish all the rights that the airspace user has on the ground. You got access, how does he get in and out, how does he get up there, where do you park your cars, you know, all the utilities that have to come up through those foundation pilings to get up there. So all this stuff has to be, you know, technologically, engineering-wise, it's a marvel. But, and legally it's pretty sophisticated too, but it can be done. And that was the first instance of it here in Fort Lauderdale, and that happened maybe 15 years ago. I know the lawyer that did it. He represented the owner of the shopping center, and the guy, the owner of the shopping center, was a clever guy. And he owned a big beachfront hotel, and he said, you know, what if we put both a shopping center on the ground and I kept it? And we sold up above to some other developer that wants to build another beachfront hotel. And you know, it was novel thinking down here. I'm sure he didn't invent the wheel. Heard that somewhere else, but it was very novel for down here, and everybody went, wow, you know. So there'll be more of that to come. That's why air rights are a big deal. Not only your right to the air, but your right to build up there. Okay. There are now 3 important concepts at the end of this chapter. I'm not sure why they're here in this chapter, but it's as good a place as any, and we don't have another place to put them. And they kind of tee up some separate areas of the law. But in addition, they make the point, and it's a good one, that real estate law incorporates all kinds of other areas of the law. You already know it incorporates contract law because we looked at a contract. You're going to see some other areas of the law here that as owner of real estate, you get involved in whether you want to or not. And they are initially suggested here as common law limitations on your right to use land. Common law is a term we haven't talked about yet, but common law is kind of, you probably heard of common law marriages. Common law is just almost not like old wives' tale, but it's like, it's the law that everybody thinks is the law, even though there's not really any law for it. There's no statute, there's no rules, or just this is generally, everybody knows what this is. And these 3 things are brought up here as limitations on your right to use your land. And the first area is called nuisance. What this is simply is that you, as owner of your land, may not use your land in such a way that it unreasonably interferes neighbor's use of his land. And you know what the term nuisance means anyway, being a nuisance to somebody. Well, as it applies to real estate, it's you using your land in a method that creates a nuisance for the guy next door. Like barking dog, bad smell, dust, all types of noise, industrial noise, party noise at night, smell from a barbecue restaurant. Everybody's driven by a barbecue restaurant and had that wonderful smell of the hickory burning. Well, that's nice, but if you live next door, might not be so nice full time.
So are these defensible in court, or?
Well, that's what this area of the law is all about. Is when is a nuisance actionable? This is not really a matter of real estate law. This is one of, all three of these are what are called torts. T-O-R-T-S. Torts is an area of the law all about civil rights for injury, whether through a touching or through an action. Torts are kind of hard to describe. Somebody once said that torts are anything you can sue somebody for that doesn't involve a breach of contract. It's like everything else. This is an example. Nuisance is a tort. Something you can sue somebody for that they're doing on their property that's bothering you. The materials talk about the courts kind of try to balance the equities and determine what's reasonable and what's fair. What's a reasonable amount of noise? What's a reasonable amount of smell? If you can establish damages, in other words, if you can say my property is worth less because of the smell that the neighbor's putting on me, and if you can determine that what the neighbor is doing is unreasonable, then you can get a court to award you damages. Too much noise, you know?
The neighbor has to be unreasonable in what they're doing?
Has to be unreasonable in his use of the property. And you have to be damaged. Those are the two tests.
Mm-hmm.
And those are the two tests in most of torts. Was it reasonable or not reasonable what somebody did, and were you damaged? It gets a lot more sophisticated than that in the law of torts, but the concepts always, very often are, was the conduct reasonable? And can you prove damages? Next one, similar, trespass. Is somebody trespassing on your property? That's usually the neighbor. Are the neighbor's trees leaning over your property? Is he trespassing on your property? Is his fence built 5 feet onto your property? Is he trespassing onto your property? Trespass does involve a wrongful physical invasion onto your property. Nuisance doesn't involve a physical invasion on your property. It involves smell, noise, soot, but not somebody walking on your property. This one is. Somebody doing something, taking over, under, on your piece of property, that's trespass. Comes up a lot in property boundary disputes. When some guy's fence is 5 feet over onto your property, as you're going to learn in another chapter, sometimes that can ripen into ownership if it continues long enough. You want to get him off there. You want to file suit for trespass and make him move his fence back, because if you don't, after a certain number of years, his use of your property continuously can ripen into ownership. But until it ripens into ownership, he's trespassing on your property. You can sue him, have the court give you damages, have the court order him to move his fence back under our example. But there's all kinds of trespassing. Walking across my front yard. You have an easement, that's fine. Otherwise, you're trespassing. You all know what trespassing is. In general, no trespassing signs, stay the hell out of here. That's trespassing. Okay.
How would you categorize a situation where I build a, you know, a tall building that has, you know, an overhang, and that overhang happens to be overhanging the neighboring property, which currently doesn't have a building on it or anything like that?
That's trespass.
Okay.
That is trespass. And you're in his airspace. Remember we just talked about airspace a minute ago?
Could you argue that he can't, you know, that's above the level where he could reasonably use his airspace? I mean, maybe not in this situation.
That doesn't,
just-
I don't think that, I think that doctrine about reasonably uses airspace was concocted as to airplanes,
Mhm.
but it doesn't give you the right to build something over it.
Sure.
For example, if I own this lot here,
Yeah.
you think you should be allowed to build a bridge over my piece of property 50 feet in the air from your property here to this property here?
No.
That's trespass.
Yeah.
That's what we're saying.
Okay.
Yeah, you do own your airspace.
Mhm.
We absolutely said, we said if you can build a 400-story high building in air rights, then you have the right to those air rights. If somebody comes in and takes that airspace away from you, that's a trespass. That's exactly the action you would use to tell him to get it off there.
Okay.
Yeah, I can't conceive of any basis where that's justifiable. Where it starts to get weird now is, okay, you built right up against the boundary.
Right.
You blocked my sunshine. You blocked my wind. My plants are all dead because they never see the sun anymore. You know, can we get into, is that a trespass or is it?
Right.
Maybe, maybe not. But the whole doctrine of coming onto my property and making use of my property rights, that's all trespass. Whether you walked in there or whether you built an overhang or whether you, by mistake, put a fence over on my side, that's trespass. Now, a third one, I'd like us to spend a little more time talking about, because I think this is a good one. This is, it is a limitation on your right to use your land the way you want to, but it's the concept of premises liability. And we're going to talk about this again and again in all kinds of different areas as we go forward. If you own a piece of property and somebody gets hurt on your piece of property, you can be liable for it. Premises liability. You own the premises, somebody got hurt on your premises, that's premises liability. Now, that's clearly the law of torts because it's about somebody getting hurt and it's personal injury. And this is where the PI lawyers have a field day. This is a slip on a banana in the shopping center. This is somebody fell down and got hurt, period. Traditionally, but this is getting to be less and less of a factor, law in this area developed based on originally, why was that person on your piece of property? What was he doing there? Well, if you had a business going, it was clearly contemplated that you would have customers. So you knew those people were going to be coming on your property. You very clearly invited them onto your property, come buy my goods. The law imposed the highest standard there. Business invitees was the term, customers. The highest standard was, you better make damn sure they don't get hurt, period. That's, you better hire somebody to pick up the banana peels to make sure they don't fall down. Make your premises safe for people that you know are going to be coming because you intended for them to be coming. Okay, that was the highest level of, the highest standard imposed upon a property owner of keep your property safe. The next lesser standard was people that came onto your properties sociably, like friends, people you invited over for an afternoon or whatever. What was your standard of care that you had to maintain for them? Well, that was a little less. It might be a friend dropping by, it was not necessarily intentional that they would be there. You had to keep your property safe, but at a lesser level. And then the third and least level of all, but believe it or not, there's always been liability in the area, is what if somebody trespasses on your property? Are you required to keep your property safe so the trespasser won't get hurt? Well, believe it or not, the law has always been pretty clear that there is some standard there. Even a trespasser, a lawbreaker, being on your piece of property, you still weren't allowed to have a landmine that you knew he'd step on.
What about like a barbed wire fence?
It's a good question. I don't know much about litigation of barbed wire fences, but you know.
Probably not military grade,
Good
razor
question.
wire.
But still, man, you still jump the fence on the property, you
You know,
really wanted to.
There were criminal law cases that we first learned about in criminal law school that kind of shocked you. Some guy was continually being burglarized, so he set up a trap gun. What's his responsibility there? Set up a trap shotgun at the front door. He knew the guy was going to be coming. Next time he got him. Is there responsibility? I don't know. You know, should there be or shouldn't there be?
Yeah.
I've got another example I want to go through with you that I think is a little less clear that we'll do in just a minute. But there's always been in the law in this area a doctrine called attractive nuisance. And what we're talking about here is what can you do with your piece of property and what are the governmental and public limitations upon your rights to do whatever you want to do with your piece of property. Swimming pools were the classic first attractive nuisance. If you put a swimming pool on your property, people will come and they will get in your pool. What standard of care do you owe? Attractive nuisance is best of all thought of with kids. Kids are going to see it and kids are going to get in it. What obligation do you have to make sure they don't get hurt? You can go further with this. You know, what if you set up a bounce house in your front yard? You didn't invite anybody, but you got one of those things going where kids jump up and down like outer space, weightless, and all that stuff. Well, you have to make sure they can't get hurt, even if you didn't invite them onto your property. It's an attractive nuisance. It's going to create and attract people. They're going to get hurt. Are you going to have responsibility? All of these things we're talking about are you as a property owner. What is the standard of care that you're required to exercise to make sure that people don't get hurt on your property? And this is all about liability insurance. You know, just like liability insurance in your car that you don't hurt somebody. I'm sure most of you know that are homeowners. You have a liability coverage portion of your homeowner policy that covers you usually for $300,000, sometimes that's $500,000 or even $1 million. Your liability as a homeowner, what if somebody gets hurt on your piece of property? What if they're walking across your living room and they trip over that lump in the rug and get hurt and get really injured? What's your liability? Well, if you get sued, insurance company's going to pay for it. Yes, ma'am.
There are cases also against dog bites.
Dog bites have been,
Right.
that's premises liability.
And it has to be in your policy.
Yeah, there's coverage and policies, and of course, it's interesting. I don't know if you're aware. I learned this recently because a friend of mine got a job doing this. A guy who was retired and wanted to do something. Insurance companies are now sending out inspectors unannounced to inspect properties that they're insuring to see, do you have a big dog? They'll cancel. Do you have a diving board on your pool? They'll cancel. They're looking for stuff. They ask you those questions now in an application, but they don't even trust your answer. And then they just go snooping around and trying to find out and canceling people that can have liability issues that they're going to have to pay for, that they just don't want to cover. Yeah, dog bites are big. That's somebody coming on your premises and the bad dog warnings but this is all about premises liability. There's a good one here in the book that I'd like to read to you. I think that, to me, this really tees it up well. And all I gotta do is sign it. But I want you to be aware of, we're gonna discuss this heavily when you get into landlord-tenant. In a landlord-tenant situation, who's responsible for this when a third party gets hurt? Is it the landlord? Is it the tenant? Let me tell you who, I'm sure it is. The lawyer for the guy who got hurt is gonna sue them both. Puts them both in a room with both of their insurance companies, and he really doesn't give a damn. Point is, let the jury look at all of them and determine how much I'm hurt, and jury and judge, you figure out which one it is. Hopefully it's the one with the insurance policy, and because they can write the check. But the point is, as between the landlord and tenant, each trying to say, it's not my fault, it's his, who is it that owed that duty to the business invitee that we talked about, to which you owe the greatest standard of care? I think this is a really good one and it's short. Page 69 of your materials. Case example. Mr. Blast owned a home with a below ground level swimming pool. A swimming pool. From time to time, he invited children in the neighborhood to come swim in his pool. Matt was 9 years old and was one of those frequent social guests. However, one night, Matt and some of his friends climbed over the fence to enter the pool area. It was dark. There was no lighting. Matt jumped on the diving board, and while he was propelling himself downward to the pool, he realized there was no water in the pool. Mr. Blast had drained the pool the previous day without notifying anyone. Matt broke his neck. Under what circumstances do you think that the homeowner should be liable for this? I think that's a really good one. And I feel like I could get on either side of it, you know? But this is the type of thing we're talking about. This is what your homeowner policy insures you against. This is what, if you don't have a homeowner policy, you're not protected against it all. But I love this one. You know, the kid was a trespasser. Climbed over the fence at night. I had a fence around my pool. If I put up a sign that says no water in the pool, would he have seen it in the dark anyway? You know? Might have to put a light on the damn thing too, for night trespassers, you know? I mean, at what point, but I invited this kid over here yesterday to swim in my pool. There was water in there, you know? Isn't it natural for him to think he could come on over tonight and have water in there? You know, I don't know. The lawyers on both sides of this thing would have a field day. And the kid breaks his neck and he may be paralyzed for life and he may have a couple of $100,000 a year of medical care times 50 for the damages. I think it's a good one.
Don't you think in that case that our insurance system has kind of, I mean, would they truly hold the person liable if there was no insurance system? But now there is an insurance system, so it's like, okay, this guy, we're not going to put this guy.
Insurance is paying. So.
Yeah, exactly. So there's almost like a, oh,
Yeah.
let's give the kid some award.
Yeah, no, you're right. They say that the worst thing in the world is for the jury to find out that there is insurance, because then it's a blank check.
Yeah.
And they think nobody really pays for this. It's just a big fat insurance company in Providence, whatever, and that they'll take care of it. But we all pay for it, right? We all put that in there, it's all built into our rates. And I say that so much of this stuff. So many of the costs in today's society are caused by trial lawyers, and so many of the warnings that you see every time you pick up a battery, it's got a thing this long of don't do this and don't do that. Because they got sued for it once, and some lawyer dreamed up a way to make them responsible, and some company lawyer helped them write all these disclaimers to try to make them not liable, you know? And you're right, if there weren't insurance, maybe they wouldn't. And secondly, as we'll talk about later, assuming it's a guy's homestead, well, homesteads are immune from judgments in Florida anyway. So even if the guy had a lot of money, the judgment would not be able to attach to the house. They couldn't force the sale of the house in order to pay the judgment. But if there's an insurance company there, everybody thinks it's free money. Okay. One more thing I want to do on this chapter, and it is to commend to you to read the section we talked about called the changing landscape on page 69. There's a lot of really well-written stuff there. And this is the beginning of the part of this course we call ethics. It talks about stewardship of land. And the concept of stewardship is our obligation to do the right thing with the land for future generations. There are a couple of really great quotes in here. I love this one. The former CEO of the Nature Conservancy says, "In the end, our society will be defined not only by what we create, but by what we refuse to destroy." As you go forward as developers and talk about paved paradise, thinking about what's the best use of this land, what's the best for future generations. There's another great line in the final paragraph. They talk about a developer is in seeking a development approval permit. And somebody says, "Vacant land, what's on the land?" Some commissioner asks. And the answer is nothing. And this author says that's the wrong answer. There's plants, there's animals, there's trees, there's water. There are things there that are important that we don't necessarily want to destroy just to pave and put up another building. We're facing this a lot in the city of Fort Lauderdale. City of Fort Lauderdale Commission has approved every apartment project that's come along for the last 3 or 4 years. They have approved project after project of 400 and 500 units of apartments all over Fort Lauderdale. But they haven't widened a road. We haven't added any more parks. We just added more people. We've log jammed the traffic now. We can't move anymore. We just keep bringing more people in. And the question is this the right thing to do? Is this good for the quality of life? And if you're a developer, then you think, of course, it's the right thing to do. Hell yes, I want to build another apartment building and make another couple $1 million. But is that necessarily the best thing for society? This changing landscape, I think, brings into focus some of the concepts that I'm supposed to try to share with you that I bet you're getting in some of your other classes anyway. But I think it's the ethics component of this class, which is just try to decide if you're doing the right thing here with your project. And that's it for chapter 3. As you know, your assignment is chapters 4, 5, and 6 for next time. If you have any questions on chapter 3, I'd love to hear them. And I have a little treat for you. I have a little practice quiz that I'd like you to fill out and answer and turn into me. This is not going to affect your grade, but it's going to do 2 things for me. One for me and one for you. It's going to show me who's paying attention today, the things we talked about. And secondly, it's going to show you the types of questions to expect on an exam from me. This is what your questions will look like, where I'll ask you a couple of questions and ask you to write 7, 8 lines about it. As we talked about before, you ought to be able to come up with that amount of the size of an answer. Any more is BS. Any less, you probably missed something. So take a few minutes, take our last 10 minutes if you would, fill those out, turn them into me, and it'll give you the flavor of what to expect on tests from me in the future. And then we're done.